The Road to Release of John Hinckley, Attempted Presidential Assassination, Insanity, Commitment, and the Courts. A program planned and developed by the Historical Society of the District of Columbia Circuit, with video produced by the Federal Judicial Center, June 27, 2024. Richard J. Bonney, Harrison Foundation Professor Emeritus of Law, Medicine and Public Policy, and Director Emeritus, Institute of Law, Psychiatry and Public Policy, University of Virginia School of Law, together with Raymond F. Patterson, MD, independent forensic psychiatrist, set the stage for a reenactment of one of the many arguments before District Court Judge Paul L. Friedman regarding Mr. Hinckley's requests for release. The reenactment is led by Barry William Levine, Blank Rome LLP, counsel to Mr. Hinckley, and Casey M. Weston, Deputy Chief, Special Proceedings Division, United States Attorney's Office for the District of Columbia, with Judge Friedman presiding. The program also includes a panel discussion on the challenges presented by the Hinckley release litigation, moderated by Professor Bonney, with Judge Friedman, Mr. Levine, Ms. Weston, Dr. Patterson, and Carrie Johnson, Justice Correspondent, NPR, serving as panelists.
Good afternoon, everyone. I am Jim Rocap, President of the Historical Society of the DC Circuit, and I'm very happy to welcome the judges of our courts who are in attendance, Chief, others, Patrick Tilley, nice to see you all. There's also judges from the Superior Court here, which we very much appreciate their coming over for this. Judge Howell just walked in, so we are in good shape, I think. So, and we're happy to have all of the rest of you who joined us this afternoon. So this is the 25th program presented by the Historical Society. In 2019, the Society named this series the Judge Patricia M. Wall Programs on Life in Law in the Courts of the DC Circuit to recognize Judge Wall's extraordinary contributions to the Society's programs over the years. This is the third in the newly named series, the Judge Patricia M. Wall series. Our topic today is one of the more unique cases the United States District Court for the District of Columbia has ever handled. It's the case of United States versus John Hinckley. Our particular focus will be on the proceedings after the 1982 verdict of not guilty by reason of insanity. Those are the proceedings to consider whether and when Mr. Hinckley could and should be released from confinement at St. Elizabeth's Hospital. So our program is going to proceed in three stages. First, the stage will be set by Professor Richard J. Bonney. Professor Bonney is the Harrison Foundation Professor Emeritus of Law, Medicine, and Public Policy at the University of Virginia School of Law. And particularly relevant here, Professor Bonney was very much involved in the legal profession's re-examination of the insanity defense after the 1982 Hinckley verdict, has written a textbook on the Hinckley case, and has included the Hinckley case in his coursework for many years at the University of Virginia. Joining Professor Bonney in setting the stage will be Dr. Raymond F. Patterson. Dr. Patterson is an independent forensic psychiatrist who served as one of the government's expert witnesses during the release proceedings. Second, in the second phase, we will listen to a reenactment of an argument that occurred in 2012 before Judge Paul Friedman, one of the many oral arguments between 2003 and 2021 leading to Mr. Hinckley's unconditional release from St. Elizabeth's. The arguments will be reenacted by Barry Levine, a highly respected litigator currently at Blank Rome here in the district, and who also served as Mr. Hinckley's counsel during the release proceedings. And also by Casey Weston, who is the Deputy Chief of the Special Proceedings Division of the United States Attorney's Office for the District of Columbia, which is the unit that handled the release proceedings on behalf of the government. Judge Friedman, who presided over those proceedings beginning in 2003, will also preside over the reenactment argument today. And finally, after the reenactment is over, Professor Bonney will moderate a panel discussion on the challenges faced by this court, by the advocates, by the experts, and by the media in the Hinckley proceedings. Joining Judge Friedman, Mr. Levine, Ms. Weston, and Dr. Patterson on the panel will be Carrie Johnson, well known to all of us as NPR's justice correspondent and also a member of the Society's board of directors. And finally, there will be a reception down in the atrium afterwards, and if you are so inclined, we would be more than happy to have you attend there. So, without further ado, I'm going to turn it over to Professor Bonney to set the stage for the reenactment.
Well, thank you very much, and I'm pleased to be here. This is a long story, as it turns out, and I must say I've dipped into it at various stages of my career, and every time I have a reason to go back into it, and particularly now, with the particular focus that we're taking today, I learn more. So I appreciate the opportunity to be speaking with you about it today. So my assignment is to set the stage for a partial reenactment of the legal proceedings relating to the psychiatric hospitalization and eventual release of John W. Hinckley Jr. from federal custody. As most of you will remember, Hinckley shot and wounded President Ronald Reagan on March 30th of 1981 as the president was walking to his limousine after an appearance at the Hilton Hotel. 3 other people were hit by Hinckley's shots. One of them, as you know, Press Secretary James Brady, was gravely injured by a wound in the head. The shooting was observed by scores of eyewitnesses and seen by millions of others on television. Hinckley was immediately apprehended, of course, by federal authorities. The Hinckley trial began on May 4th, 1982, and lasted 7 weeks. The transcript of the trial exceeds 7,000 pages, most of which are devoted to testimony relating to Hinckley's primary defense, that at the time of the homicidal conduct, he had been legally insane. On June 21st, after deliberating for 3 days, the jury returned a verdict of not guilty by reason of insanity that precluded criminal punishment for each of the 13 crimes for which Hinckley had been charged. He was thereafter committed to St. Elizabeth's Hospital, also, as you know, here in Washington, where he remained under inpatient order until May 12th, 2015, when the district court approved a plan for him to live under judicial supervision in Williamsburg, where his parents were living. Judicial supervision was terminated altogether 6 years later on June 2nd, 2021. 4 decades of litigation highlight several questions of interest to us today. The first question is, what was Hinckley's state of mind at the time of the offense? The disputed question at the trial was not whether Hinckley did not what he did, but why he did it. The evidence and argument presented by the prosecution and the defense reflect 2 very different answers to that question. As everybody knows, the jury found that Hinckley was legally insane. I will return to that question in a minute. The second question of interest is, was the jury's insanity verdict sound? Given the magnitude of Hinckley's crimes, it is no exaggeration to say that the insanity defense itself was on trial in this case. Should Hinckley have been convicted and punished for the attempted assassination and other serious offenses with which he was charged? The third question of interest to us, and the primary topic today, is, what were the legal consequences of the jury's insanity verdict? Since Hinckley was not subject to punishment under the penal law, the determinative question after the insanity verdict were whether he posed a danger to society, and if so, what should be done to eliminate that danger. After the insanity verdict, Hinckley was committed to a secure forensic ward at St. Elizabeth's in Washington, as you know, where he remained for nearly 40 years before being discharged to outpatient status in 2015, as I mentioned, and then being unconditionally released in 2021. As I said, this is the main focus of the program, and there's a lot to be said about those questions. But also there's the question beyond what happened and what the basis for the decisions were, was John Hinckley treated fairly during this entire 4 decades? Should he still, conversely, be under judicial supervision today? So, before focusing on that central question, we need to spend a few minutes just discussing the expert testimony in the Hinckley trial, since it provides the foundation for what has happened afterwards. The central question, as I posed it earlier, was what was the matter with John Hinckley when he attempted to assassinate the president? This question bears on the persuasiveness of Hinckley's insanity claim, as well as on whether he posed a danger to society after his trial, and for that matter, whether he continues to pose a danger to society today. These questions direct our attention to the expert testimony at the trial, which seems to present 2 divergent accounts of what motivated John Hinckley. Why did he attempt to assassinate President Reagan? The trial testimony in the Hinckley prosecution provides a fascinating case study of the clinical and moral grounding of the insanity defense. It bears on the backward-looking question, did he deserve to be punished? But it also bears on the forward-looking question that we are addressing today. Was he dangerous in 1982, and if so, is he still dangerous? To help us address these questions, it is instructive to consider the very different accounts of Hinckley's motivations that were presented by the prosecution and the defense at the trial, so that even though that's not our main focus here, it is a predicate for everything that has happened since. The prosecution's account was that Hinckley felt that he had special talents. This is a tremendous oversimplification, of course, of, as I said, 7,000 pages of testimony. He had felt that he had special talents and was destined to be famous, and that carrying out daring deeds would attract the admiration of women, and particularly the actress Jodie Foster. The main expert witness for the prosecution opined that Hinckley's behavior was grounded in a developing psychiatric disorder, specifically narcissistic personality disorder. Quite simply, Hinckley desperately wanted to be famous. By itself, of course, his pathological motivation is not exculpatory. Quite the reverse. Nothing about his psychopathology affected his ability to appreciate the wrongfulness, the horrible wrongfulness of his conduct. He knew that his conduct was illegal and that he was likely to be punished for it. That's the prosecution's account. The defense account of Hinckley's motivation and state of mind was quite different from the prosecution's account. The defense expert testified that Hinckley's understanding of the meaning and likely consequences of his behavior had been severely distorted by psychotic thinking. Specifically, he believed that assassinating President Reagan would demonstrate his love for Jodie Foster, and would thereby connect them in eternity or for eternity, however one thinks about it. When coupled with severe depression, his profoundly disordered thinking rendered him, to use the language of the insanity defense, unable to appreciate the wrongfulness of his conduct. When he planned his offense, when he was awaiting President Reagan's arrival at the Hilton Hotel, and when he fired the life-threatening shots. In lay terms, we can all see that John Hinckley was a very disturbed young man. Neither of these explanations for his behavior is normal, but the one account implicates the moral grounding of the insanity defense, and the other does not. In such a case, the ultimate judgment belongs to the jury. And as you know, the jury accepted the defense account and found him not guilty by reason of insanity. What I am saying is that the insanity verdict was morally and legally defensible in Hinckley's case, even though there was this reasonable disagreement. In retrospect, based on the intensive clinical attention that Hinckley received over the past 40 years, the generally accepted answer to the question that I posed earlier is all of the above. What was the matter with John Hinckley? All of the above. At the time of his arrest, he was a deeply depressed young man with multiple psychiatric disorders. His understanding of the world and his place in it were distorted by both narcissism and psychotic thinking. For purposes of our program today, we will assume that the jury reached a defensible verdict, both clinically and legally. With that brief account of what was the matter with John Hinckley in mind, we now turn to the main subject of our program today. We will focus exclusively on Hinckley's hospitalization and treatment in the wake of what I'm characterizing as a defensible insanity verdict. The next step is hospitalization. So he wasn't convicted, he wasn't sent to prison, he was sent to St. Elizabeth's Hospital. After the jury returned its insanity verdict in June of 1982, Hinckley was automatically committed to St. Elizabeth's under highly secure conditions. For the first 17 years, Hinckley was not permitted to have any unsupervised freedom of movement outside the institution, and all trips outside the grounds of St. Elizabeth's were closely monitored. This 17-year period was followed by a period of 4 years when the court allowed short visits outside the institution with his parents, followed by longer visits with them in Williamsburg. Then, in 2012, nearly 30 years after the attempted assassination, he was allowed short periods of freedom in the community without supervision. Finally, as I mentioned, in 2015, he was conditionally discharged from St. Elizabeth's and was allowed to live in Williamsburg with ongoing judicial oversight. In June 2021, John Hinckley became a free man. The question of greatest interest in this case study, the questions of greatest interest in this case study are, first, why it took so long until 2015 for the court to allow Hinckley to live outside the hospital under a conditional discharge, and second, whether John Hinckley was treated fairly over these 40 years. On one level, Hinckley's case is a representative case. It nicely illustrates the substantive considerations and procedures that govern the disposition of all insanity acquittees whose offenses were violent. However, on its own terms, John Hinckley's case was uniquely challenging for everyone involved. For the hospital staff and forensic experts charged with assessing, treating, and managing the patient and making recommendations to the court. For the attorneys representing the United States and Mr. Hinckley, and especially for the federal judges who had to absorb periodic lessons in psychopathology as I've already given you a taste, to cope with the intensive public interest in the case, not to mention the special needs of the Special Service, of the Secret Service. To give you a first-hand account of the unique challenges faced by Judge Friedman and the responsible advocates in the Hinckley case, the reenactment will focus on a hearing held in 2012, about 30 years after Hinckley's commitment, at which the court was considering a plan to allow him to have periodic, unsupervised visits with his family in Williamsburg, as a first step in a transition that, if successful, would lead to a conditional discharge and a return to normal community life. An important question is why it took so long. What were the government and the independent evaluators worried about after such a lengthy period of close oversight and supervision? So what will follow now is a short presentation by Dr. Raymond Patterson, as was mentioned earlier, summarizing some factors bearing on John Hinckley's condition and treatment leading up to the important hearing in 2012. Followed after that by a reenactment of that hearing. After the reenactment, we will convene key participants in the case for a panel discussion focused on the hospitalization and treatment of John Hinckley, culminating a decade later in his discharge from legal supervision as a free man. So with that background, I'm going to turn this over to Dr. Patterson, over here. Here you go.
Good afternoon. I am Dr. Raymond Patterson, and I'll be talking about some of the clinical issues on the road to unconditional release of John Hinckley Jr. I will be focusing on the conditional release process at St. Elizabeth's Hospital in the District of Columbia, and more specifically on issues affecting John Hinckley, including his diagnosis, his treatment plan, his adherence to treatment, and the impact of court orders. The coordination of treatment, both at St. Elizabeth's and in Williamsburg, is critical in this case. My intention is to speak only of the matters that are public record. I will not address areas of treatment that remain confidential and privileged. Mr. Hinckley was committed to the hospital in June of 1982. He had not been examined by any of the hospital staff prior to being found not guilty by reason of insanity. Did not know him. Therefore, the hospital staff had to review all the reports from the experts who had testified at this trial and any other relevant information, hospital or other, that may be relevant to his particular situation. The treatment team first developed the treatment plan, identified his primary diagnoses and the areas of concern, and identified treatment objectives and goals. Mr. Hinckley's diagnoses were 1, psychosis, 2, major depression, and 3, narcissistic personality disorder. The treatment plan addresses those 3 core issues, as well as other concerns associated with his pathology, behavioral issues related to those diagnoses, together with positive supports and risk factors. So we had to consider everything. The treatment team also monitors improvement or lack thereof of factors identified in the treatment plan. Risk analysis continued and were modified as his circumstances changed over the years. Developing risk analysis was essential, and it's important for me to say that the approach taken by the hospital staff and by external experts, including me and others as time went on, was largely focused on updates on the status of his mental disorders and on risk assessment and risk management. The risk factors that Mr. Hinckley were clearly elucidated in Judge Friedman's summaries and orders. that were very, very clearly identified and commented. They included depression, isolation, psychosis, lack of insight into his mental illness, narcissistic personality disorder, lack of family support, a history of suicide attempts, difficulties in relationships with others, and deception. Obviously, a paramount aim was to prevent access to weapons of any kind. Mr. Hinckley was placed in a maximum security unit and appeared to be responding positively from the outset. He was compliant with treatment recommendations, including taking his medications. However, the staff was surprised in February of 1983, 8 months after admission, when Mr. Hinckley took an overdose of medications that he had been hoarding in an attempt at suicide. He had to be rushed to an outside hospital. Fortunately, he survived the attempted suicide. More surprises were in order for the treatment staff, however, mainly grounded in his narcissistic personality disorder. In early 1986, Mr. Hinckley filed a pro se motion requesting a less restrictive placement, including unsupervised visits in the District of Columbia 1 time per month. The hospital opposed those requests, while noting that his psychosis and depression were in remission. The report emphasized that his narcissistic personality disorder and his lack of judgment and insight into his illness continued to be major concerns. During this process, hospital staff discovered that Mr. Hinckley had made unauthorized communications with the news media. His motion for a less restrictive placement was denied. After a successful supervised Christmas visit with family in 1986, in April of 1987, the hospital requested permission for Mr. Hinckley to have an unsupervised Easter visit with his family. However, after making the request, the hospital became aware that Mr. Hinckley was in blatant violation of the restrictions banning him from communicating with the public. One example was a letter Mr. Hinckley had written to a woman in another state requesting her to smuggle a pistol into the hospital and facilitate an escape, or alternatively, requesting her to go to New Haven and kidnap Jodie Foster and demand his release so that she could be brought to him. Another example of his narcissistic personality disorder occurred at the hearing itself, when an independent psychiatric expert retained by Mr. Hinckley testified that Mr. Hinckley was writing to Lynette Squeaky Fromm of the Charles Manson family, asking for Manson's address, and he was also writing to Ted Bundy, calling Charles Manson a, quote, cool dude, unquote. Judge Parker then ordered the hospital to notify the court of any visits into the community from that point on, and directed the hospital to search his room and all of his papers. In so doing, the hospital found over 50 photos or drawings of Jodie Foster that Mr. Hinckley had been keeping contrary to his assertions to both the hospital staff and the independent psychiatrist that he had no longer any interest in Ms. Foster. Continuing concerns about Mr. Hinckley's narcissism, grandiosity, and deception continued for decades. In 2003, Judge Friedman, who had taken over the Hinckley case, scheduled a major hearing, including multiple experts on both sides. All of the experts agreed that the major mental illnesses, specifically psychosis and major depression, were in remission, sustained remission. And all but one of the experts agreed that his narcissistic personality disorder was neither in remission nor significantly attenuated. As a result of this hearing, the staff initiated a process for allowing conditional release with several anticipated phases involving visits to Hinckley's parents' home in Williamsburg and a gradual transition of responsibility to the treatment providers in Williamsburg and at the hospital, with the ultimate goal of unconditional release if and when approved by the court. During this time period, the staff supervised outings in Washington, D.C. continued as Class B privileges, meaning supervised by hospital staff. The process began as phase 1, including one-day visits with his parents within a 50-mile radius of the hospital and unsupervised by staff. Each of these visits required careful review by the hospital and progressed to phase 3 by 2006 with extended visits to the family home in Williamsburg. Based on continuing improvement, Mr. Hinckley made 24 phase 3 visits. In 2009, phase 4 visits were ordered by the court as a, quote, transitional stage, including increasing levels of privileges, some unsupervised time for vocational activities, work, and social activities, supervision by his mother and siblings in Williamsburg, and securing mental health providers in Williamsburg. It also included approved itineraries for the days that Mr. Hinckley would spend in Williamsburg. Mr. Hinckley also obtained his driver's license during this time period and was authorized to drive while carrying a GPS phone. Mr. Hinckley's Williamsburg treatment team was finally assembled and began providing individual, group, music, therapy, case management, and medication management services. However, phase 4 goals had mixed success, and the Williamsburg treatment team and St. Elizabeth's outpatient department were charged with addressing some remaining problems with Mr. Hinckley. That brings us up to approximately 2011, the next major court hearing, and that hearing is the foundation for the reenactment that will now be presented. Thank you.
Thank you, Professor Bonney, and thank you, Dr. Patterson. So we will now turn to the reenactment. Judge Friedman is going to don his robes, and he magically will become a judge and take the bench.
Well, counsel, we just finished a hearing that lasted 13 days. 13 days of testimony, and the usual suspects, of course, we had experts from both sides, from the hospital, experts retained by Mr. Hinckley on behalf of the family, experts retained by the government, and we now are at a point where incrementally Mr. Hinckley has had 33 10-day visits to Williamsburg with his parents, and largely unsupervised. Of course, there have been many conditions, as you know, and a support team of psychiatrists, psychologists, case managers, again, all of them paid for by the Hinckley family at this point, since I allowed him to go to Williamsburg with conditions. And he's got 3 hours of unaccompanied time twice a week in the community. And that's the problem, Mr. Levine, that we saw during the course of this hearing, that despite the fact that he's been very compliant with all of the conditions over the years, there were a couple of incidents that occurred while on this particular visit that give me real concern about your request and the government's request that I should extend the visits from 10 days to 17 days a month. But, you know, we've all heard the testimony, and I want to hear what you and Ms. Weston have to say. I should draw what conclusions I should draw from what we've heard over the last 13 days.
Thank you, Your Honor. Please the court. The events that bring us here today occurred about 30 years ago, and the momentous nature of those events not lost on us. He has expressed in many forums his profound regret. He wishes he could erase the events of that day, but of course he can't. The fact is that he could not appreciate the wrongfulness of his act at that time, and the fact is, as the jury found, he was ravaged by mental disease. That disease was the basis for the acquittal and the remand into the mental health system of the Department of Justice. He has received his constitutional right to treatment. Now we have 30 years of experience, of data about his recovery. We have, as the court just noted, some 200 supervised excursions into the community. We have many, many conditional releases with his family, the last 33 of which have been 10 days in duration. There have been, after each of these releases, written reports. During each of these written reports to the court, each of these excursions or outings into the community has been on notice or with notice to the Secret Service. They were free to follow and surveil as they chose.
And they did,
and we never had an objection to it.
Well, some of the things that happened on this last visit were reported to us by the Secret Service.
Well, that's right. I'm going to be talking about that. Your Honor, he's had the treatment from teams of countless professionals. These are remarkable people. These are people who are dedicated to restoring mental health. These hearings, and this one in particular, shows the success of their efforts. Their efforts and the evidence, their efforts, which is the evidence, justifies the relief we seek, which is expansion of his closely watched freedoms. While the law of insanity has changed since the trial, the law about post-verdict release has not changed. It is well known, it is well settled. Is he a danger to himself or others as a result of a mental disease? These hearings are about that question, and whether he suffers from a mental disease that causes danger. And only that and that alone is what this hearing is about. And the hospital...
Well, there are two questions under the statute, right? Is he still mentally ill?
Is he mentally ill?
And is he a danger?
And is he a causal relationship between the two? Is he mentally ill, and has that resulted in him being dangerous? The hospital has answered those questions, and they have done it in an unequivocal way. They've sent a letter to the court, and it says that it asks the court, proposes to the court, that his liberties be enlarged incrementally to expand from 10 days to 17 days, then from 17 days to 24 days, and then from 24 days to convalescent leave. And the hospital concluded that the risk of danger during those conditions, during a release with those conditions, is decidedly low. The hospital also concludes that he has no symptoms of mental disease.
Currently.
Currently, exactly, currently. That's the letter that triggered this hearing. Now, just as no one is above the law, no one is below the law. That's not sloganism, Your Honor. To honor the law, we must follow it. The appellate courts instruct these trial courts that his sanity, equity must be held in the least restrictive condition consistent with public safety. And the burden is an easy one. The burden is mere preponderance of the evidence. All that need be proven is that it is more likely than not that he will not be a danger to himself or others as a result of a mental disease under the conditions proposed. The evidence has shown.
So you're not at this point arguing that the conditions I've imposed each time he's been released and his privileges have been expanded. You're not arguing against the conditions.
We are not, and we never have, Your Honor. As a matter of fact, there is no condition to which this court that this court has imposed. My memory serves me accurately, to which we objected. Any condition at all was okay with us.
And there are about 30. There are about 30 conditions in my current order.
Yes, and we object to none. The hospital has said, it has advised the court, and I think it is virtually a stipulated fact that the mental disease is Axis 1, which is the primary diagnosis.
Which is depression and psychotic disorder.
Psychosis not otherwise specified, an OS, and major depression, and they are and have been for I think as many as 24 or 5 years in full, stable, sustained, complete remission. His Axis 2 diagnosis, the narcissistic personality disorder, the secondary diagnosis, has been denominated by the hospital as significantly attenuated. This hearing, which as Your Honor notes, was 13 days and involved carefully scrutinized evidence. It has followed the same pattern as the previous hearings. The hospital presented a reasonable proposal for incremental release, incremental increase in freedom. It was supported by the unanimous review board after consideration of all of the risk factors.
You've got about 3 or 4 minutes to go, Mr. Levine.
I'm sorry, Your Honor?
You've got about 4 minutes. So why don't you get to the issue? The issue, the government's going to get up here and they're going to say that there was an incident or a couple of incidents on this last visit that should give me pause about extending from 10 to 17 days. And, to go to your last point, and I'm going to give you more than 3 minutes, but to go to your last point, the concerning diagnoses are the Axis 1 diagnoses. They are the ones that cause someone to be dangerous, as I understand all of the testimony, and they're in full remission for a long time. What narcissism does not make you dangerous, but narcissism has certain characteristics: deception, isolation, being guarded, lying. And so much of what we rely on with Mr. Hinckley, what I rely on to give myself confidence, is self-reporting. And now we have a situation where while he was in his last visit, or 2 visits, I think, he went into a bookstore when his itinerary, and we have daily itineraries, as you know, of what he can do when he was on his own, instead of going to the movies. And then he lied to his treatment people in Williamsburg about going to the movies. So that's an act of deception. That doesn't make him dangerous, no, but my question is, can I continue to rely on his self-reporting and on more and more freedom for him?
Well, I think, Your Honor, the evidence shows that for this court to know what happened, and for the hospital to know what happened, there are a variety of sources of information, all of which corroborate. There is corroborative sources of information on which the court should rely, so it need not rely on his self-report. But the important point here, the critical point for this hearing, is that he's done nothing dangerous. He may not have He may not have told the truth on some occasions, but he didn't do anything dangerous. The government talks about things he did in the 1980s, which were his correspondence, his possession of certain photographs. All of those things were true. He did those things, but he did nothing dangerous. And the question before this court, and the question before this court, and the requirement of the application of law is he dangerous as a result of a mental disease? And if he was deceptive, it's poor judgment. If he didn't comply or deviated with his itinerary, that's poor judgment. But it's not evidence of danger. And the application of the law, no one is below the law. The application of the law is that without a danger as a result of a mental disease, this court must grant this motion.
Okay.
Now, I have much more to contribute if
Well,
there's
don't
time,
let it-
but I'm being told there isn't, so I know when the court says sit down. Thank you.
Thank you, Mr. Levine. Ms. Weston.
Thank you, Your Honor. May it please the court and counsel. Your Honor, in his report, Dr. Manobano described Mr. Hinckley as lying about the movies by being motivated by his desire to present himself in an overly positive manner. He wanted to show his treatment team that he had completed every step of his itinerary. He wanted to project a positive image of himself to his treatment team. Your Honor, the hospital's risk assessment and plan share the same fault. Every mistake by Mr. Hinckley is minimized. Every risk is downplayed, as we just heard from Mr. Levine. And the hospital and Mr. Hinckley continue to ask this court to cede its authority and discretion to the hospital and to allow the hospital to determine if and when Mr. Hinckley should be placed on convalescent leave. When the court considers all the evidence in this case, and as Your Honor stated, this was a long hearing for several weeks now. When you consider all the testimony that you've heard, the witnesses, most of the weight being given to the expert witnesses Your Honor heard from, this court has to reach its own conclusion. This court owes no deference to the hospital's decision or their opinion. This court must decide whether Mr. Hinckley has shown by a preponderance of the evidence that under the proposed conditional release, he will not be a danger to himself or others. Mr. Hinckley and the hospital have not met that burden, and we are asking that the court deny the petition. Now, Your Honor, the government believes that because of all the hyperbole associated with this case and because of the visceral reaction that many people have to Mr. Hinckley, we want to start by saying that we think it's important to say out what we're not asking for. The government is not saying that Mr. Hinckley should remain indefinitely at St. Elizabeth's. We are not asking that this court end the conditional release that exists currently. We're not asking that the court end his B-City privileges. The government's position is simply this, that Mr. Hinckley's visits to Williamsburg should remain at 10 days. And then if and when he is accepted into the People's Place and programs there meet his needs and are appropriate, that they should remain at 10 days.
Well, but wait. Mr. Levine didn't discuss this point. But People's Place, this facility that we talked about at another part of the hearing that might accept him into their program, I thought they had reported that he would have to be there for more than half a month for them to even consider whether to accept him. So, I mean, you're creating a catch-22 here.
Your Honor, the problem right now is that it's a speculative question, and he has not been accepted into those programs.
But if he
court
can't
could
be
certainly
accepted if
reconsider.
he's only there 10 days a month,
But it hasn't even been identified at this point whether the programs there are even appropriate. And as Mr. Beffa testified, Your Honor heard, he himself doesn't even know. He says all of the programs would be appropriate. There's no discerning. He hadn't even really looked into the specifics of the particular programs available at People's Place. So without knowing that information, Your Honor, the government submits that it's not appropriate to concede that step at this stage without having more specifics, certainly in this case. All we are asking, Your Honor, is that he not have any unaccompanied time while he's in Williamsburg, except for when he's in his mother's community. And we ask that the court maintain the notice provisions for his B-City outings so that the Secret Service can adequately prepare for staff events that he may attend. Should this court decide that Mr. Hinckley and the hospital are correct and that he should not have an itinerary but instead should be allowed to pick from a menu of options on any particular day, the government in that circumstance would ask that he wear an ankle monitor so that the Secret Service can accurately monitor him. I do want to begin with what was already discussed regarding Mr. Hinckley's diagnoses and the questions the court previously asked. And Mr. Levine is correct, and the court certainly knows that Mr. Hinckley's Axis I diagnoses of psychosis not otherwise specified and major depression are in full remission. The government is not contesting that. His Axis II diagnosis of narcissistic personality disorder remains. Doctors Murphy and Montalbano suggest that his narcissistic personality disorder is somewhat attenuated. Dr. Patterson and Dr. Phillips disagree.
Well, they've disagreed with Mr. Hinckley in the hospital at every hearing that we've had since 2003.
What's important here, though, for the court to keep in mind about those diagnoses, Your Honor, is that the mere lack of an overt danger and the resiliency that Mr. Hinckley has shown in several rebuffs over the years is that that remission is in place largely because he is being treated at St. Elizabeth's and because he's on medication. Indeed, he's receiving nearly the maximum recommended dosage of Zoloft.
But he's receiving the same medication in Williamsburg, where Dr. Gigiano is monitoring that every week.
Your Honor, as you heard from Dr. Gigi and as we talked about with Mr. Beffa, these are both competent, wonderful people who have the best interests at heart. However, Dr. Gigi is still relatively new to Mr. Hinckley. And this question before Your Honor is really, what are the risks outside of St. Elizabeth's? What are the risks under these proposed conditions of release? And assessing that, as you heard from Mr. Levine, Mr. Levine asked this court to look at each individual incident or each data point independently and in a vacuum and decide whether they each alone make him dangerous. Does wearing a ring make him dangerous? Does not wearing a ring make him dangerous? Does playing golf or not playing golf make him dangerous? In that way, Mr. Levine's argument is a very standard defense argument. Does each individual piece of evidence prove a defendant's guilt or innocence? But as Your Honor knows, a brick does not make a wall. This court must look at the totality of the circumstances and all the evidence in the case. As Drs. Patterson and Dr. Phillips explained, this would be an easy case. It would be a short hearing if there was overt signs of danger, but there's not. The question here, however, is the management of risk and the management of danger in the community. So let's look at some of those risks that the government believes remain in place today. The first is deception.
Are risk and danger synonymous, or are risk factors factors that together add up to dangerousness?
The latter, Your Honor. Okay. The first we want to focus on is deception. And as Your Honor noted earlier, deception is an important factor. Why is it an important factor? Well, as Judge Green, previously sitting for this court in 1997, wrote, quote, "The patient has a history of deception and a record of screening information, is otherwise obliged to provide treating and examining clinicians. That history included his deception of writing to Ted Bundy, included his deception collecting pictures of Jodie Foster and hiding them in his room at St. Elizabeth's." She continues that the history of this case suggests a deceptive individual who has in the past deceived those treating him in ways too numerous to count. That history makes it even more incumbent upon the petitioner to be especially forthright and open with his current treating clinicians. Judge Green continued that seemingly trivial transgressions must be measured against this past. The same remains true today, Your Honor. Let's look at just a couple instances of deception that Your Honors heard about during the course of this hearing. First, you heard about the Christmas party in 2008. Your Honor will remember that Mr. Hinckley invited 2 women to that Christmas party. Government would submit that's not a great choice for anybody, but more importantly, when questioned about that, he told Mr. Chambly that he had discussed it with Dr. Raffanello. And when Mr. Chambly spoke to Dr. Raffanello, she in fact said he had only asked her opinion, and she told him it would be a bad choice. He was placed on board hold. Then in 2009, there was an issue with a dental resident at the hospital. On April 27, 2009, Mr. Hinckley went to the dental clinic at St. Elizabeth's for an emergency. He complained of pain in his tooth, and when told that his regular dentist was not there, he declined pain medication and said he'd come back the next day when she was there. The next day he went. She determined he needed to come back in 6 months and he needed certain treatments. He went back, not 6 months later, but on May 20th. He again declined treatment. He went to see her again on June 2nd, again declining treatment, this time saying that he wanted to talk to her about his trip home to Williamsburg. Finally, on June 11th, 2009, 45 days after he went there for an emergency visit, she repaired the inclusion. That same month, Mr. Hinckley looked up pictures of the dental resident on the internet at St. Elizabeth's library computer. He said she gave him permission to do so. The dental resident said she did not. Dr. Murphy told Dr. Phillips that she wasn't that concerned about the objective truth in that dispute. And the testimony Your Honor heard that there was a rule, an oral rule, but a rule nonetheless, that Mr. Hinckley was to ask for permission before using the library internet. He broke that rule, and he was placed on ward hold. Lastly, Your Honor, there's the movies, another act of deception. In July 2011 and again in September 2011, he reported to Mr. Chambly that he went to the movies. He went further and recommended that Mr. Chambly should go see the movies, Captain America and Rise of the Planet of the Apes. He told Dr. Patterson that he had seen the movies. He told Dr. Phillips that he had seen the movies. He even recounted to Dr. Phillips the plot of the Rise of the Planet of the Apes, which led Dr. Phillips to know he was lying.
And Dr. Phillips had seen the movie?
Apparently so, Your Honor. Some things never change. I think there's a new Planet of the Apes movie now. When Dr. Patterson confronted him with the Secret Service reports that said otherwise, that said he didn't go to the movies, Mr. Hinckley said it's not a big deal and that Dr. Patterson and the Secret Service should just cut him some slack. It was only after the hospital took action and on the eve of this hearing, Your Honor, on November 28, 2011, that he admitted that he did not go. And even then, he still lied, saying that he didn't go because he didn't want Mr. Chambly to think he was cheap. The hospital responds to these lies, calling them unreliable reporting. Mr. Levine just called them unreliable reporting as well. They're lies. The hospital, in Mr. Hinckley's view, is that despite those lies, because each of those lies don't themselves endanger anyone in and of themselves, that we should just proceed with their plan. 2 visits of 17 days, 6 visits of 24 days, and then, without any further approval from this court, proceed directly to convalescent leave.
Got about 2 minutes.
Your Honor, isolation remains a serious problem for Mr. Hinckley as well. It is undisputed that he has made no friends in Williamsburg despite his visits there. To his credit, he does volunteer at the Eastern State Hospital where he works in the library 2 days a week for 2 hours. But he has not shown any initiative to follow up on any of the suggestions made by Mr. Beffa to help him socialize in Williamsburg. And as Dr. Gigi noted, Williamsburg can be a tough place to move for anyone. But the unfortunate reality is that it's even harder for Mr. Hinckley. It's not easy for him there. The court has seen the itineraries, it's seen the post-visit reviews. He goes to the movies, he goes to the same pet store, to the same electronics store. He simply has no social outlet there and no friends. Yet the hospital's position is to give him more unstructured time in the hope that with more time he'll do what he has not yet done with the visits he has. Your Honor, Mr. Hinckley has made progress, and it would be silly for the government to dispute that he has made progress. The question for this court, though, is what weight to give his steps forward in relation to his steps backwards. Mr. Levine suggested that the court should find that the testing and VRAG and HCR20 are more persuasive than Dr. Phillips and Dr. Patterson's testimony. But those tests are merely single predictors and not in and of themselves sufficient. Mr. Levine also has taken issue with Drs. Patterson and Phillips over a few things. This court should make no mistake about it. They are well paid, and you've heard from them now several times. But the court is also well aware that their opinions are not based on the fact that they're retained by the government. They have disagreed with the government in this case, and they've disagreed with the government in other cases where they've been retained. They frequently are retained by defense counsel and the courts. As to Dr. Patterson, let's remember that it was Dr. Patterson who years ago recommended Mr. Hinckley go on risperidol for the express purposes of his eventual release into the community. And it was Dr. Patterson who said that treatment works and that he has received the best health care within the public health care system. Your Honor, going back to Judge Green, this is from her opinion in 1997. She quoted from Mr. Hinckley's diary, "Psychiatry is a guessing game. I do my best to keep the fools guessing about me. They will never know the true John Hinckley. Only I fully understand myself."
That's from an opinion from Judge Green?
Quoting from Mr. Hinckley's diary.
Uh-huh.
Judge Green wrote, quote, "It is particularly disturbing that when this statement was written, Mr. Hinckley had undergone 5 years of treatment and had convinced his treatment clinicians that he had recovered sufficiently for conditional release. Your Honor, that in and of itself is the reason the deception, the isolation, those risk factors are incredibly important and relevant to this court's determination as to Mr. Hinckley's dangerousness. And when you consider all the evidence, the conclusion should be that Mr. Hinckley is in need of more monitoring, not less, and we ask that you deny the e-petition. Thank you.
Mr. Levine, do you want 2 minutes for rebuttal, or will you stand on your argument?
Rarely without the ability to say something. Your Honor, what she didn't say, and what the doctors never said, is that he's dangerous. In the last 25 years, he has done nothing dangerous. That's the question before the court. Is he dangerous as a result of a mental disease? That's the question. And when he wrote that in his diary in 1987, in the context of this case, antiquity, or when he looked at photographs of the dentist in 2009, or when he invited people to the Christmas party, I think in 2007, whatever one might think of his judgment in that regard, he did nothing that was dangerous. And that's the law that the court has to apply. Was he dangerous as a result of a mental disease? As we said repeatedly, Your Honor, John Hinckley is not flawless. He's not particularly gregarious. There are times when he wants to be alone, but he is not a danger to himself or others.
Thank you, Mr. Levine. I will have an opinion for you in due course. We've had 13 days of hearings, and the issues the two of you have focused on this afternoon are not the only issues I have to address. Thank you.
Well done by everybody. Thank you very much. So we are now going to move to the panel discussion, and we're going to just take a minute for everybody to be able to get up on the judicial dais.
So if I understand this correctly, Judge, now that you have your robe off, I think I'm to invite you to reflect on what has just occurred and get us started on our next conversation.
All right. First, let me say, as I sit here in our ceremonial courtroom and looking at the back wall, we have portraits of retired and deceased judges. I see Barrington Parker, who tried the case, presided over that lengthy criminal trial. He's a great judge. And June Green, who presided over this case post-trial before she retired, I think at the age of 98. And I got the case from the great Judge Green. So I pay a tribute to them for all their work on this case. So what I ultimately did after this hearing is I issued a very long opinion and an order. And I essentially, I think I took Barry's point that what are the real issues here? Is he a danger, and is he still mentally ill? And the major illnesses had been in remission for well over 23 years. I thought even longer at this point in 2013. And is he a danger to himself or others? And I basically concluded that with conditions that would minimize the risk, and I think in many of the hearings, Judge Patterson, Dr. Patterson, his primary arguments became over time that managing risk is the issue. He's not as, they always said what happened in 1986 and 1992, but the further you got from those events, those things became less important, even though the statute says I'm supposed to consider the entire record, which I did. But his argument always was, he's still dangerous. We can manage the risks that may lead to the danger, but I think you need a lot more conditions than the hospital and Mr. Levine think. And I imposed lots and lots of conditions. So after this particular case, I essentially said, I read a long opinion. I talked about what all the witnesses said. I said, yes, he lied, but that's deception. And it was affirmatively done in covering up his deception, and all of the issues about the lying conjure up the symptoms of narcissism and the inability to rely entirely on his self-reporting and the inability of his treaters to be able to rely on him as they dealt with him. But we then, or shortly thereafter, had a really good treatment team in place in Williamsburg. Dr. Gigi, who was managing the medication, Mr. Beffa, who did both individual therapy and group therapy, and then Mr. Wise, who was the case manager, who tried to get him involved in things. So, despite the government's argument, which was essentially leave the status quo for a while and see what happens, I issued an order expanding, after this hearing, expanding his time in Williamsburg to 17 days a month. And gave a lot of reasons in my written opinion, and I think at that point had a total of 29 conditions. Maybe it was more than that, but a lot of conditions. And that's what I did. I did not rely exclusively on the going to the movies and the lying. And there was this other issue we didn't discuss today about when he didn't go to the movies, he went into a bookstore, and there was all this testimony of whether he was looking at books on assassinations of presidents. And the truth was, he wasn't. And when the Secret Service agents testified, they said he wasn't. The problem is that the government's opening statement, it wasn't Miss Weston, said that he was, and the press picked it up, and it was a real problem for him and his family for a while. In any event, I expanded the time in Williamsburg, in part because I thought it would enable him to explore these other options at the community health center, or whatever it was called, in People's Place, and in part because I wasn't going to take these several isolated incidents and say they undermined all the progress he had made. So that's my short answer to that question. Unless you have a follow-up.
Barry, do you want to?
Well, I think the deception issue is a very interesting one. I mean, the government's opening statement was the major deception in this hearing. It made a statement that said he went into a bookstore and he didn't look at music, he didn't look at literature, he didn't look at poetry, but he looked at books on Reagan and assassination. It was electrifying. The press went wild. It was broadcast globally, locally. It didn't just create a problem for Mr. Hinckley and his family. It created a problem for the community. That was the community that became really frightened that this man was coming to live amongst them. And it wasn't true. None of it was true. The memorandum from which the government made its opening statement was a memorandum drafted by the Secret Service. It said exactly the contrary. It said he didn't focus on any book. He didn't touch any of the books in the American history section. Rather, he went to the music section. Rather, he picked up a book on British music. He went to the literature section and looked through magazines. At the end of his stay in the bookstore, he bought a greeting card and a book on Bob Dylan and Elvis. The truth could never catch up with that lie. And that was the deception that haunted and pervaded this case. That was the deception.
I would say pervaded that hearing and the aftermath, not the entire case, but I'll let the
I
government speak.
I would agree with that, pervaded this hearing.
I guess I have
Casey,
to
do you
respond to
want-
that. I think I'll start by saying, as all the judges in this room have told me many times, a government's opening statement is not evidence in a case. And the evidence speaks for itself, and I believe what the evidence actually was the Secret Service agents were quite clear about what they saw and what they didn't see. They testified about what they were able to see, what parts of the store he went to. I don't disagree that at the end of the day, the evidence did not establish that he looked at a particular book. But nobody argued, certainly after the evidence came in, or ever stated otherwise. The agents were quite clear about what they did and did not see, and that did include standing in front of a shelf on books on American history for an extended period of time,
20
which they
seconds.
did testify to, compared to other shelves that he looked at in the store. So, again, I think it was clear based on the actual evidence in the case what they saw and what they didn't see, and they didn't try to oversell what they saw, and the government never said otherwise. As Judge Friedman noted, we cut out a lot of the closing argument in this case, but that was a large part of the argument, and the government made very clear in its closing what was and was not evidence in the case.
Ray, do you want to weigh in on this?
Well, I'll
this
just
issue?
I'll just add a little bit to it, and then we can certainly move on. The issue about the deception was really, really important to all of the examiners, whether they were a hospital or retained by defense or prosecution, because it was long-standing, it wasn't new. And before the assassination attempt, no one saw him as psychotic or as having a major depression. And all of that came about during the evaluation and assessment phase. And to separate the Axis One, then we'd all, the psychiatrists and psychologists of the world, changed all of that nomenclature. But to separate the serious mental illnesses of psychosis and major depression from a severe narcissistic personality disorder, for us, that does not exist. We can't just say it's either or. They are not mutually exclusive. So we have to consider what elements are part of both of those. And if they're in remission, that's fine. But they seem to have not been present or in remission before all this happened. And there was always testimony, well, if he decompensates, it's going to be slow, everybody will see it. Really. Only if they're looking. Only if there's that kind of monitoring, that kind of actual risk management. So for most of us, it had to do with risk assessment and risk management. I'll give you a real quick example that makes it even more clear. Let's say that different person has those same two diagnoses and is also an alcoholic. The alcoholism didn't result in an NGRI, but if we were to say, well, these are in remission, let him go out there, he'll be fine, and he drinks and then gets himself into a world of trouble, how do we justify that we didn't pay attention to the other conditions in that person? So it all comes together. You have to consider them all together. I'll stop there.
May I make this observation? This issue of his conduct and deception, although it's portrayed here as being, as Dr. Patterson says, very important, it seems to have occurred very rarely. This gentleman was in St. E's and was one of the most scrutinized people, I dare say, in the world. He was watched daily on the ward. He was watched when he went on B-City releases into this community, supervised. He was watched when he was on his job at St. E's. He was watched when he was in Williamsburg. He was scrutinized with uncommon intensity. So this is a person they knew everything about. He couldn't hide characteristics for 20, 30, and 40 years. He was watched day and night. So when you come to a hearing and they say, he went to a bookstore instead of a movie, or in 2008, he invited inappropriately people to a Christmas party and then didn't tell the truth about why he did it, or whether he had permission to do it, or that in 2010 or 9, whatever it was, that he used the internet to look at graduation pictures of his student dentist and her family. How can that be the basis of denying a person liberty when nothing dangerous occurred?
Barry, I want to respond to that too. First of all, the last example of the dental assistant obviously conjured up in the minds of Dr. Patterson and the hospital treaters. Is he stalking this person? There were other examples at St. Elizabeth's too. Is this just like Jodie Foster, and is that a problem? But let me preface what I want to say with this. One of the challenges for a judge in a case like this, or in any really complicated case, I'm looking at my colleagues here, I'm looking at Chief Judge Josie Herring over there, in any really complicated case like this, is learning enough, whether it's an antitrust case, whether it's a patent case, but in a case like this, learning enough about psychiatry and psychology and the way people like Dr. Patterson and the experts that Barry and the Hinckley family hired, how to analyze what they're telling me. Because Barry's right. John Hinckley is the most analyzed guy ever. And one of the things I said somewhere in writing or orally is, every judge in this courtroom knows that we make decisions every day of the week to let someone out on probation, to detain him or not detain him, whether to sentence him or not, on so little information compared what I got over 20 years in this case. It's unbelievable. And sometimes something happens and we get criticized for it in the press. But of the thousands and thousands of cases that Judge Josie Herring and her colleagues in Superior Court and the hundreds of cases the judges in this court have released people on bond, there are gonna be some mistakes. We have a pretty damn good record in my view, the judges in this city. I had so much more about this guy, but to try to do it right, I really had to get in the weeds and try to understand. I'm not saying Dr. Patterson will tell you whether I was successful or not. It's a rhetorical question, Ray. Try to understand this hard stuff about somebody who came this close to killing a president of the United States. It was a hell of a challenge.
So I would like to pick up on the fact that you just made those observations and move us to 2015. You reached the decision and wrote an elaborate opinion reflecting what you have learned from these many days and weeks and months and years working on this, and reaching the judgment that it was time for Hinckley to have the opportunity to be living in the community, and had resolved some of these concerns. Obviously, it was continued oversight that was going to be provided at that point. But I personally find, I read that very carefully, your elaborate opinion. Well, you have become a very good clinician, judged by someone who's not a clinician. Okay, at least put it that way, but I think Ray might have something to say about that issue as well. So in the period of time that we've been talking about here, between the uncertainty, I think, that was pretty evident in what you said previously. You had reached a different judgment, by the end of I can't remember exactly what the year it was in 2015. And maybe you can make some observations about that, and Ray can kind of weigh in on that as well.
Well, I guess the simple answer is, why did I decide to let him out? And the simple answer is, why not? 20 years since the attempted assassination, 20 years of incremental steps, and he passed almost every test during that time. I wrote an opinion, was just said, that it's very lengthy. It is one of the few opinions I've ever written that has a table of contents. But I'm going to answer your question, Richard, by reading 2 paragraphs from that lengthy opinion. They're the first and third paragraph of the opinion. In 1981, John W. Hinckley Jr. was a profoundly troubled 25-year-old young man suffering from active and acute psychosis and major depression. His mental condition had gradually worsened over the preceding years, beginning as early as 1976, ultimately resulting in a deep obsession with the actress Jodie Foster in the film Taxi Driver. Mr. Hinckley began to identify with the main character in the film, Travis Bickle, who unsuccessfully plots to assassinate a presidential candidate in order to win the affections of a young woman. At numerous points in the years leading up to 1981, Mr. Hinckley traveled to Yale University in New Haven, Connecticut, seeking to establish contact with Jodie Foster, leaving notes, letters, and poems at her dormitory, and even speaking with her on the phone several times. After failing in his effort to establish a personal relationship with Miss Foster, Mr. Hinckley then sought to impress her through stalking President Jimmy Carter, traveling to Washington, D.C., Columbus, Ohio, and Dayton, Ohio, over a 3-day period in September of 1980. On October 9th, 1980, Mr. Hinckley was arrested with several firearms and ammunition in the suitcase at Nashville, Tennessee Airport, where President Carter was scheduled to make a campaign appearance. I'll skip the paragraph about what he did in March of 1981, because we all know. The next paragraph. Today, more than 34 years later, Mr. Hinckley is 61 years old and suffering from arthritis, high blood pressure, and various other physical ailments, like many men his age. He has been under the care of St. Elizabeth's Hospital for over 3 decades. Since 1983, when he last attempted suicide, he has displayed no symptoms of active mental illness, exhibited no violent behavior, I may have the year wrong, Ray, shown no interest in weapons, and demonstrated no suicidal ideation. The government and the hospital both agree that Mr. Hinckley's primary diagnosis of psychotic disorder not otherwise specified and major depression had been in full and sustained remission for well over 20 years, perhaps more than 27 years. In addition, since 2006, Mr. Hinckley has successfully completed over 80 unsupervised visits with his family in Williamsburg, Virginia, fully complying with the court's strict conditions with 2 minor exceptions, which we've talked about today. The government and its expert, Dr. Raymond Patterson, an independent expert who conducted a comprehensive risk assessment in this case, Dr. Catherine Murphy, and all of Mr. Hinckley's treatment providers, both at St. Elizabeth's and in Williamsburg, now agree unanimously that Mr. Hinckley is clinically ready for full-time convalescent leave, and with certain conditions, he will not be a danger to himself or others. After carefully considering the relevant authorities, blah, 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 and Mr. Hinckley's entire history and a clinical record over 34 years, the court will grant the hospital proposal for full-time convalescent leave in Williamsburg, Virginia, with additional and modified conditions as discussed below. And I did that with 35 conditions and ultimately released him completely. That's the story. The man he was at 61, with the help of St. Elizabeth's Hospital and all the treaters there, and the medication, all the counseling, and the treaters in Williamsburg, he was a very different man at the age of 61.
And I thought it was the power of my advocacy.
I think having psychiatrists teach was also helpful. So here's, having reached that point, I would like to have Kerry Johnson weigh in on this now, thinking about the public reactions to this very 4-decade story that we've just heard, and including the fact that John Hinckley is a free man today. So would you tell us some things that are on your mind?
Sure, I think I covered the last 15 years of this litigation. And I remember the first time I walked into the courtroom and saw Mr. Hinckley sitting there, and it kind of took my breath away, having last seen him on television when I was a very small child in the early 1980s. He certainly wasn't the same person I had seen on television in that era, and yet public interest in this case, as Barry said, was enormous. And there was a lot of pressure. There was a lot of pressure from people in the community. Reporters were quite interested in Mr. Hinckley and what he was doing, and every time there was, as Judge Friedman has described, a glitch in his compliance with conditions, public interest and media attention grew all over again. But one of the interesting things about this case, which went on for so long, was that it went through generations of prosecutors. You know, one of the early US attorneys in this case told me years later, "I believe anyone who tries to nullify a presidential election with a bullet forfeits their right to walk free in society." And over time, there were generations of prosecutors who raised objections to conditional releases of Mr. Hinckley. And then by the end of this process, most of those people were quiet. But I will say, and I think I need to say, that the Reagan Foundation, at the time of his full and unconditional release, issued a statement saying John Hinckley is still a threat. And former President Reagan's daughter, Patty Davis, has been quite vocal about how the idea that people's memories of this terrible tragedy may have faded, but in her mind, she wrote, that event is a prison and there is no release for her. And so this was the push and pull of this case. I mean, I think Judge Friedman has said, and other participants in this case have said in other settings, that no one but John Hinckley would have been observed and confined for this long. And at the same time, Hinckley, as we have seen, had the most zealous of defenses over all these decades. And he had extraordinary family wealth and family support, in particular from his mother, that many people in these situations never get.
Anybody else want to weigh in on that?
Kerry and I have talked about this before, but the first time I let John out for that one short visit with his parents, I had threats. I had phone calls and voicemails at the office, and I want to withdraw the word threats. And Meryl Tufanian, who's here, who was my clerk at the time, and Sonia Pfaffenroth, who was the other clerk at the time, will remember this. And so will my wife Liz, who's back there. We were very concerned, and the Marshal Service was concerned. And Liz and I had Marshal protection for about a week. The only good news was it was during the Christmas season, and so, you know, going to Christmas parties was like having a chauffeur, but it was security, and that's not any fun, as some people in this room know. But the marshals looked into it, and they found out nobody was really threatening me. These are people who were just loyal to one of the most popular presidents, Ronald Reagan, who was nearly killed, and they were just venting. And they were no danger to anybody, and they had every right to vent. And Patty Davis, even though every time I did anything, she wrote something or spoke somewhere, had every right. This was not easy for people. The original prosecutors in the case, large segments of the public, and so it was not easy for any of us who were involved in this post-trial litigation either. So that's the only thing I would say in response to Kerry. And
I would augment that and tell you that John felt terrible. He agonized all the time about what he had done. There was no ability to reverse what he had done. You know, there's an interesting dynamic here. Being sick enables one to live with the misdeeds. Getting well forces you to come starkly face to face with what it is that you have done. And that has agonized him since he's been well. He continues to bear that very heavy weight. The president himself, Mr. Reagan, was very magnanimous. He was concerned about this young man. But it wasn't so with respect to many of the other of his victims.
Well, I will say
Sarah
this.
Brady.
Sarah Brady was great. Sarah Brady wrote me a letter asking that I not release John the first time around. And I mentioned it in court that I had received this letter from Sarah Brady, and Barry properly said, well, if you've seen it and it might affect you even in the slightest, I have a right to see it. So we reached out through the victim's witness unit at the U.S. Attorney's Office to Mrs. Brady and said, do you have any objection if this is released publicly? And she said, no, just so long as you redact address and all that sort of stuff. We did. And so she objected, and for obvious reasons.
And we fully understand it. And we understand the public passion, the general opprobrium of the public. We understand the judicial disapprobation. We understand it all. We understood that this was a heavy lift for us. But I think in the end, the justice system did well. It applied the law. I mean, I haven't said this to the judge personally, but I'll say it now. I mean, I can think of no better judge a judge who was deliberative, he was cautious, he was careful, and he applied the law. He did justice.
Thank you, Barry.
Well, I actually think that's a suitable note on which maybe to end this. It was exactly my thought here as well. I think it was inevitable. I think clearly the insanity verdict was the right verdict in this case for the reasons that I was implying in my earlier comments. Whatever the series of disorders that he had and the combination of them, it would have been a mistake to convict him and punish him. Now, obviously people can still have judgments about that, but on the other hand, once the insanity acquittal had been handed down and we were then on the therapeutic path here in a way that protects the public, it does seem to me that it was entirely appropriate for this to take as long as it did, particularly given the nature of his condition and the uncertainty that only began to resolve in the time period that you all have been talking about this evening, I think. And I think that, as you mentioned earlier, I think you were responsive, to when things changed and they began to be evident that they had changed, to be able to respond properly, to doing that. And I think the public over time needs to understand all the things about this case that y'all were collectively referring to just now. But one of them was that it took time within the therapeutic setting for a very complicated case to unravel its secrets over time and to provide an opportunity for him to be responsive, even to the point that now he's a free man. Yeah. So I think that is a wonderful, endpoint to this. So I think you have directions, I think, for the group.
First of all, I would like to thank Professor Bonney and all of the panelists for a wonderful program. As I mentioned, the program is being recorded. It will be available later this summer, and I would urge you to let everyone know about it, because I think it is a tremendously insightful program, the comments that we've heard from all of the participants in the proceedings over the years. So that's the end of our program. We do have a reception downstairs in the atrium in the Bryan Annex with good food and mild drink and good fellowship, hopefully. So be happy to invite you down and enjoy your company if you're so inclined. Thank you very much.